Without further ado, we are going to get started. Again, welcome everyone. My name is Elizabeth Aloni. I'm with Schneps Media. Schneps Media is the largest local media company in the New York metro area. We publish over 70 newspapers, magazines, websites, webinars, podcasts, and events throughout Queens, Brooklyn, the Bronx, Manhattan, Westchester, Long Island, and Philadelphia. Today, we are thrilled to bring to you the webinar Medicaid 101, How to Secure Long-Term Care in the Community. Now, Medicaid laws are changing, and it is more important to plan so that your loved ones can remain safe at home. I'm thrilled that today we have a top elder law attorney and Medicaid specialist, Moriah Adamo, partner at Abrams, Fensterman, who will provide information and strategies to ensure your loved ones can maximize services under the new Medicaid laws. Another interesting tidbit is that Moriah was named a power woman by Schneps Media. So please, everyone, join me in giving a warm welcome to Moriah Adamo. Welcome, Moriah. Please tell everyone a little bit about yourself.
Well, good morning. Thank you, Elizabeth, and thank you for everyone tuning in. I am Moriah Adamo. I'm a partner with Abrams Fensterman. I head up our elder law department here in our Lake Success office. We also have offices in Brooklyn, Metro Tech, Manhattan, White Plains, and Rochester. So as such, I've had the opportunity to handle Medicaid and elder law issues all the way from Suffolk to Essex County and all points in between. So I'm going to go ahead and pull up my...
I'm sure with your broad geography, all of the Zoom and whatnot makes life much easier.
Yes, it sure does. It is helpful to have that background and to have the breadth of the law firm behind me. It's given me a lot of opportunity to handle many diverse cases and interact with people of all different backgrounds in order to assure their families and their loved ones get the care that they need and deserve in the community. And Elizabeth, I'm just going to ask you, can you see my PowerPoint at this point?
Yes, I can. I can see the main point, and then I also see a smaller slide there. Perhaps you go into slideshow view.
I'm in slideshow view.
Let's just try it one more time.
Is that better? No?
That's the regular view.
I'm gonna try again.
Bear with us, everyone. You know,
sorry for the technical difficulties.
None of us are perfect at it, but we're all getting better. I could say we're all probably 100% better than we were a year ago. Is that not true? And it's wonderful to be part of such a large firm because you're able to help people across many different
geographic and economic and demographic varieties of all shapes. So how's this? Are we?
John said Shift Control Enter if you're on a Mac.
Nope, I'm not on a Mac. Thank you, John, though.
Yes, John.
This was working earlier, so I don't know what's going on now.
Budget overview. Okay.
How about now?
That's good. That's still, we could see it. Go ahead.
Okay. So this is my contact information. And today what I wanted to focus my conversation on is really securing long-term care in the community. So many of us and our loved ones really want to live out their life in their home, in their apartments that they have known for many, many years and never wish to be institutionalized. So today's conversation is going to center around those plans and those goals. And there have been significant changes to that model that were introduced in April of 2020 with the 2020-2021 New York State budget. Significant overhaul to the Medicaid program was instituted. And today we're going to focus on the effect to community Medicaid. And there's really two buckets of change change. There was financial eligibility changes, and that came in large part through the imposition of a penalty period for community-based long-term care services. And then there was also changes in how to access the care once you're determined to be Medicaid eligible. How do you actually secure the services that you need to be able to age in place in the community? So we're going to review both of those, what I call buckets of change, both the financial and the access to services changes. And then finally, we're just going to touch upon one other major change, which was the phase out of the managed long-term care. And if you don't know about anything that I'm talking about right now, that's okay. Hopefully by the end of this, you'll have an idea. And as Elizabeth mentioned at the top, please feel free to put questions into the chat. This is very dense and Byzantine information, so I'm sure there will be plenty of questions. So when I'm talking about Medicaid and long-term care in the community, I thought it would be beneficial to start out by showing you what programs are actually available through our New York State Medicaid program. And in order to access Medicaid, it is a needs-based program. So there's a financial eligibility criteria to it. In addition, you have to demonstrate the actual need, the physical needs for the services. And Medicaid in New York is broken up into three distinct categories. There's a straight community Medicaid, which is represented by this first column. This covers your doctors, your hospital visits. Then there's this middle piece, community long-term care. Now, this is really what we're going to be focusing our conversation on today. And this covers home health care services in the community, a home health aide coming in to assist an individual with their activities of daily living so that they may age in place. It also covers assisted livings. There are some assisted livings in New York State that do accept Medicaid, and those services are also provided through this community long-term care-based Medicaid. And then the final category of Medicaid in New York is called institutional or chronic care Medicaid. And this is what covers the nursing home. And for many of you, you may be familiar with this level of Medicaid because this is where there has traditionally been this 60-month look-back period that you've probably heard about. But today, again, we're going to be focusing on this middle component, which is accessing home care services in the community through community-based long-term care. And we're going to look at the changes that have been taking place within that realm. So in order to understand Medicaid eligibility and the changes that are occurring, you need to understand two distinct concepts, a look-back period and a penalty period. Now, these concepts generally get lumped together. They are working together in parallel and in tandem, but they're two distinct eligibility criteria and concepts that I'd like to go over. It starts with the understanding that, as I indicated, Medicaid is means tested, right? So you have to demonstrate financial eligibility. And for the year 2021, an individual may retain $15,900 of available resources in order to qualify for Medicaid. If a couple is applying together, that number is bumped up to $23,100 of available resources. There's also a spousal allowance for married individuals as well, and that's listed there. So what has happened historically is that individuals will engage in strategies to deplete their assets in order to bring them down to those allowable levels to then access the care that they would otherwise have to privately pay for at exorbitant rates, right? So Congress caught on to this many years ago and said, hey, we're not going to just allow people to give their money away and then apply for Medicaid and secure Medicaid reimbursement for their care. Rather, what we're going to do is impose a penalty period for the transfer of assets done in order to qualify for Medicaid. So that's where we introduce this look back and penalty period concepts, right? So a look back is the period of time for which the Department of Social Services, which is the agency that processes the Medicaid applications, will review an applicant's finances. So we know this with the 60-month look back for institutional Medicaid, the Department of Social Services will look at 5 years of bank statements. That's the look back period, okay? And what they're looking for, of course, is transfers of assets for less than fair market value. Why? Because they will then impose a penalty period based upon those transfers that occurred within the applicable look-back period. So a penalty period is a period of time that a person's ineligible for Medicaid. And that penalty period starts when the individual is what's called otherwise eligible for Medicaid, meaning they're below the applicable resource allowance and they're also in need of services. So a common misconception is that you engage in Medicaid planning and then you have to wait 5 years or wait the applicable look back period in order to qualify for Medicaid. That's not necessarily the case because it's not necessarily a full 5-year penalty based on the amount of assets that are transferred. So what happens is, for the applicable look-back period, any gifts that were made, transfers of assets for less than fair market value, are divided by these regional rates, okay? And then it's determined based on that division, that's how many months of ineligibility an individual will incur a penalty for. So, by way of example, sometimes the best way to understand things is just to do an example. So Billy Bob, he lives in Nassau County, okay? Over the past few years, he gave a total of $13,843 to his children. Convenient number for him. In May of 2022, okay, so sometime in the future, he fell and broke his hip. And he's no longer able to independently care for himself at his home. He does need assistance with his activities of daily living, so he desires to apply for Medicaid. He puts in his application. The applicable look-back period is applied. So he puts the financials in support of his application, and they discover this gift, this aggregate gift of $13,843. So they go back to this handy dandy chart and they say, okay, well, he lives in Nassau County. He's given away $13,834. We're going to divide that by our divisor and come up with the number 1. And so he's ineligible for Medicaid for 1 month from the date of his application. That is how the look back and the penalty period work in tandem. An understanding of that is necessary to understand what has been changing in this environment.
Right. I have a quick question about that.
Sure.
So if he had given away less than that amount of money,
correct,
would he still be penalized? And would it be a portion of a month, or is
yes.
that okay?
Correct. Yes.
So it's really prorated based on from $1?
Yes, that's
okay.
correct.
Okay.
That's correct. So they aggregate the total amount of the gifting throughout the look back period. They divide it by the applicable divisor, and then whatever that number is, so it could be 0.8, for example, is the amount of time for which the individual is ineligible for the services that they're applying for.
Thank you. That
Okay.
yeah.
So what does this all mean in the lands of community Medicaid? Well, prior to the budget in April of 2020, there was no look back period and no penalty period for securing community Medicaid, meaning that someone could fall and break their hip. Billy Bob could fall and break his hip in May of 2022, transfer all of his assets in May of 2022, and then qualify for community services in June of 2022. But facing a major deficit, the legislator and the Department of Health determined that that's no longer appropriate in New York, and they have determined that they're going to impose a 30-month look-back period for community-based long-term care services. Okay. So a 2.5 year, that was the compromise that they struck, rather than the full 5 years that's applied to institutional Medicaid. This look back period will be 2.5 years. It applies if the individual who is applying is either aged, which is 65 or over, blind, or disabled. This is the population of people that would be seeking to secure those home care services that we're talking about today. And it penalizes uncompensated transfers of income and assets that was made on or after October 1st, 2020. So you'll note that that October 1st, 2020 date is a date in the past now. So for any transfer of assets that is made after that date, that magic date, there will be a penalty period imposed once the state actually starts implementing this 2.5 year look back period. So as of now, as we sit here today on May 4th, currently the state is not yet imposing the look back period, okay? So you put in an application for home care services today, and you're not gonna have to put in the 2.5 years of financial service, financial records to support that application. It's kind of up in the air as to when they are going to start this. And it looks like it may be not until January 1st, 2022. Where am I pulling that from? It is nothing in writing. It is nothing in any sort of legislative or administrative authority. That date is coming from the state's waiver request to the federal government that was put in a recent proposal. So it could happen, the imposition of the look back period can really happen anytime between now and January 1st of 2022 under the current law. We just don't know. So what I've been advising clients is we're operating on borrowed time. If you feel like you may need or qualify for home care services, now is the time to put in the application. We're going to be talking more about what it means to actually qualify for the services in a few moments. But right now, as we sit here today, the look back period for community Medicaid has not yet started. But once it is commenced, once the state gives the green light to the Departments of Social Services to start this look back period, any transfer of assets made on or after October 1st, 2020 will be subject to that penalty period. Just in case you thought you might get out of a webinar this year without talking about COVID, I have bad news for you. The whole reason the commencement of the look back period is tied up and unknown, and we don't really know when it's going to start, is because the commencement of the look back period is tied to federal COVID funding that we have been receiving, the state has been receiving. So New York State has accepted federal dollars with the string attached that they're unable to make changes to the home care program until the state of emergency has been lifted. So everything is kind of tied together, and right now we're kind of going on a month-to-month state of emergency. So we'll have to see and just keep tuned as to when this is actually going to start. But there's no time like the present to start planning. So we really have been working in earnest in our office to navigate these new changes and bring strategic gifting and planning strategies to our clients in light of these changes that we know are coming forward. So with that, let's talk a little bit about that planning. So first of all, there's some good news here, right? Not all transfers of assets are subject to penalty, right? There are some transfers of assets that are exempt from the imposition of the penalty period, even if they occurred through the applicable look-back period. So whenever we talk about Medicaid planning, we talk about two aspects. There's eligibility for Medicaid, and then there's also Medicaid's right to recover assets. So certainly the sooner we start planning, the more opportunity we have to plan both for eligibility and for recovery. And that's going to become very important when we start talking about the homestead. But as of this slide, we're just going to talk about the transfer of any asset, right? This can be these transfers to these classes of people are exempt from penalty, regardless of the nature of the asset that's being transferred. So you can transfer cash and you can do so to a child with a disability without the imposition of a penalty. Now, this child does not have to be a minor. It can be an adult child. And when we say disability, this is a disability as recognized by the Social Security Administration. So if an individual is on Social Security disability or SSI or would qualify for either of those benefits, then the transfer of any assets to that child of the applicant is exempt, meaning it will not incur a penalty period. In addition, you can transfer to a trust for the sole benefit of any disabled person. No longer has to be your child. If it's transferred in a trust, it could be any disabled person. So this comes in handy if it's a grandchild, a niece, a nephew, just a good friend, a sister. So any individual that is disabled can be the beneficiary of this type of trust, or a trust for the sole benefit of the applicant's spouse also works as an exempt transfer. Outright transfers between spouses is also exempt from eligibility purposes. Now, we want to be careful about that because the state can sometimes recover from a spouse of an applicant, right? So again, we always want to keep in mind eligibility and recovery rules. But in order to qualify for Medicaid, you can transfer assets between spouses on an exempt basis. There's also the ability to present evidence that any transfer made within the applicable look-back period was not done for the purposes of qualifying for Medicaid, but there is a legal presumption that has to be overcome. So this is a pretty high burden, and it usually requires a hearing in order to be able to overcome that. But I throw that in there because it is instructive to the next conversation, which is specific to the homestead. So I just said the class of transfers on this slide, these transfers to these individuals is good for any type of assets. The homestead under Medicaid law, this is your home, your primary residence has special treatments, okay? You can own your home with equity of up to $906,000 exempt, okay? You can own that. It doesn't count towards that $15,900 asset. And that will not interfere with your eligibility for Medicaid. So long as the applicant, your spouse, minor child, or blind or disabled child is living in that house, it's also an exempt resource, okay? Which means that it can also be transferred exemptly to these individuals as well. There's also a statute in New York that provides additional classes of exempt transfers for Medicaid applicants for institutional Medicaid, okay? So if you're looking to secure institutional Medicaid, there's these additional classes of individuals to whom you can transfer the home. Your sibling with an equity interest, as long as that sibling was residing there 1 year before the date of institutionalization, and or the caregiver child, so long as that child was living in the home up to 2 years before the date of institutionalization. And those quotations before the date of institutionalization are significant because that's taken right from the statutes. And today we're talking not about nursing home Medicaid, not about institutionalization, but keeping people in the community, right? So there's a lot of hubbub in my world, the elder law world, about whether or not the transfer to these classes, the sibling and the caregiver child of individuals, would be exempt for long-term care purposes, for community-based purposes, because that language appears in the statute. There's speculation that it would not apply to community-based long-term care, so that the transfer to a sibling or a caretaker child for community-based services may not be exempt, right? Not to fear though, because there's certainly other planning opportunities available to us. And as I mentioned, you can always access the care without any transfer at all, because the equity, again, up to $906,000 in the home is exempt from consideration for eligibility, okay? So those classes of exempt transfers offer us significant planning opportunities, right? Because we can make those transfers, assuming that those individuals would be the intended objects of your bounty, or the people that you ultimately want to benefit at any rate from your estate. They would be exempt. You can make the transfers, and then the asset would be exempt for both eligibility and recovery purposes. However, not all of us have those classes of individuals in our life, or there may be reasons why transferring outright to an individual may not be appropriate. Perhaps the individual has their own disability, or just transferring your assets to a child, for example, exposes those assets to your child's liability, your child's marriage, your child's divorce, all sorts of other implications from outright transfers. So as Medicaid planners, we very often utilize trust agreements. Okay, and I'm sure almost everyone has heard of a trust. Some people get very concerned and overwhelmed by the idea of creating a trust. I'm here to tell you that they are not as scary and as erudite as one may expect. They're not just for the Carnegies and the Rockefellers, they are for us. They really provide a lot of flexibility in our planning. And simply a trust is just an agreement between three individuals. It's an agreement between the creator, who may also be referred to as the grantor or the settlor, the trustees, and ultimately the beneficiaries. So I always use this example to explain what a trust is and to bring it to life a little bit, because everyone can relate to this, right? So I'm a mom. I have two really adorable, cute, curly-haired little girls. And I also have a doting mother / grandmother. And a couple of years ago, my mother came over and took the girls out for a day. Like all good doting grandmothers, she hopped them all up on sugar and arrived back at my house about an hour before dinner time. And when she walked into the house, the kids running ahead of her, ready to tear up the toy room, she walked in with these two big lollipops, you know, like the big ones, the ones that cover the kids' faces, right? The good ship lollipops. And she hands them to me with that knowing look, like I know enough not to give them any more sugar right now. And she hands them to me and she says, "These are for the girls. You can give them to them, tomorrow or whenever you feel is appropriate." So what just happened there? My mom created a trust, right? She gave me her property, her lollipops, okay? And she told me how to administer them, right? She said, hold those lollipops until you, trustee, think that the beneficiaries, my daughters, will like them, want them, and it's appropriate to give them to them, right? So that's all a trust is. It's important to know that the beneficiaries of a trust have rights against the trustees, right? So the next day when my daughter saw the lollipop sitting on top of the refrigerator, you know darn sure they said, "But Mom, Grandma bought those lollipops for us," right? So the beneficiaries have rights against the trustees. Now, of course, trust can be a little bit more complicated than that example and have many more provisions and some tax implications, but it really just boils down to that very basic understanding of the individual providing property to a trustee to hold for the benefit of another individual according to their instructions. And we have trusts of all different varieties and flavors, right? We can have an inter vivos trust or a testamentary trust, right? Inter vivos is a trust that's created during your lifetime and funded during your lifetime, whereas a testamentary trust is created in your will and does not take effect until you pass away, and at that point it's funded. You can have a revocable trust, a trust that you retain significant authority over, and you can always say, enough with this, I'm going to revoke this trust, versus an irrevocable trust, which is irrevocable transfer of assets that you cannot unilaterally undo, right? So you can have an inter vivos revocable trust, an inter vivos irrevocable trust, but you cannot have a testamentary revocable trust. Why? Because the testamentary trust does not become effective until you pass away. And when you're dead, you're unable to revoke anything. So a testamentary trust by its very nature is irrevocable upon your death. So for our purposes today, we're going to focus on an irrevocable trust.
That was a great explanation, by the way. You just made it very easy. I've heard many of these terms and I still Google it in my head, and that was very, very cool. Thank you.
Oh, good. Thank you. So, I mean, everyone can relate to a grandma and lollipops.
Yeah. Great analogy.
An irrevocable trust is the type of trust that we'll use for Medicaid planning, okay? It's an irrevocable transfer. So your transfer of the asset to the trustee cannot unilaterally be done, right? And the other significant part of these types of trusts is that once you put the assets into the trust, you as grantor or creator or settler divest yourself of access to the principal, okay? Any income that is generated, you may access, but the principal balance of the trust, you're kind of locking away for prosperity's sake. And because you're irrevocably transferring it, locking it away, you can be sure that it is a gift that's going to be subject to a penalty for that look back period, right? But it protects the asset from both the eligibility and recovery purposes, okay? So you have to be careful about the assets that you would want to put into these irrevocable trusts. So I spend a lot of time with my clients going over appropriate planning opportunities. It's a great vehicle for your homestead. If your intention is to remain at home for as long as you can, or to die in your room, like so many of my clients tell me, then the irrevocable trust for your home is really a great planning opportunity, because it doesn't really change your relationship to that home. If drafted properly, you can retain the right to remain in the home for the rest of your life. You retain all your enhanced star benefits that you may be entitled to. So it really doesn't change your relationship to that home as it would if you put $100,000 of cash into the trust that you can no longer take out to go on a cruise, for example. So the nature of the asset that's going into the irrevocable trust is certainly significant, but it really does provide you with great planning opportunities on a going forward basis. So that's one example of a planning strategy that we use when we have time, right? So I said that, there's no time like the present to start planning. So that's so true. But sometimes life happens, right? And you haven't done any planning, and you find yourself or you find a loved one in need of services immediately, and there's just not been any planning done. I am here to tell you it is never too late. In almost every case that I've encountered, we have had the opportunity to do some sort of planning, even in a crisis or an emergency situation. And one way that we do that is by utilization of something called a promissory note. And through promissory note planning, we're generally able to save a family between 40 and 60% of any assets that would be considered available. And this is a strategy that we use whereby we make a calculated gift, and that gift can either be outright to individuals or to a trust. So we know exactly what penalty period is going to be triggered by the gift, okay, because we'll have the calculations. And we'll know then how long the person's going to be ineligible for Medicaid. With the other percentage of the assets, we'll enter into a Medicaid compliant promissory note, a loan agreement that would be used to pay for the care that the applicant needs during the calculated penalty period. So we use the gift as a way to get money out to intended beneficiaries, and the loan as the mechanism to pay for the care and services that would be needed during any applicable penalty period. So I know that's super complicated and it blows people's minds every time, but if you take away nothing else, is that there's always opportunities to do some planning. So if you or someone you love needs services and there's been no planning done, never fear, we are here, and we can, so many occasions, help people even in a crisis. These are just the legal requirements for a Medicaid promissory notes, and we will assure that any note that you enter is compliant. So that's a little bit of background on financial eligibility for Medicaid and the planning. And believe it or not, that's actually the easy part. Okay, it's very easy for us who know, who have done this and have experience, know what we're doing, to plan financially and to make people Medicaid eligible and protect assets from recovery. There's defined rules and there's a lot of case law on these issues. That's kind of the easy part. What's more difficult and what also comprises a large part of our practice is actually helping our clients access the care once they're financially eligible, and also maximize those services to which they're entitled. So that's like a whole nother component of our practice that really sets our practice aside, because we are litigators. We have this large firm behind us, so we have the resources and the connections to be able to really dig into these cases and advocate for our clients. So accessing care is so often overlooked, but is really, at the end of the day, you did all that planning in order to get the care that you need. So it's really critical to the process. So there have been significant changes to how care is going to be accessed in the community on a going forward basis. And I'm going to go over those. But really, in order to understand the changes, we first have to understand what the process is currently. So I just want to go over that real quickly. First, you get the financial approval through the Department of Social Services. Like I said, that's kind of the easy part. Certainly there's complications to it, but it's not as subjective as accessing the care. Okay, so once you get the financial approval, you get a notice of approval in the mail, and then you're going to call New York State and set up what's called a conflict-free assessment. This is a nurse assessment, so that's going to occur nowadays. So they've been done on the phone, but prior to COVID, they were done in the home, where the nurse would come out and observe the applicant and ensure that the applicant was appropriate for the long-term care program, meaning that that individual had a disability that rendered the need for assistance with activities of daily living, and that disability was expected to persist for 120 days or more. So once the individual clears that conflict-free assessment, then they're required to enroll in a managed long-term care plan. This is simply an insurance plan that administers the Medicaid program. It's Fidelis runs one, Integra, Freedom Care. You've heard a whole bunch of these names probably. These are just the insurance companies that receive the Medicaid dollars and then administer the care. So you would choose one. The consumer will choose a managed long-term care plan to enroll in after that conflict-free assessment. And then the managed care company will send out their own nurse in order to do a second nurse's assessment. And this time, the nurse will determine how many hours of home care services the managed long-term care plan will award that particular individual. Okay, so that whole process from financial approval to actually having an aide in the home providing the care generally takes about 2 months. So after you get the notice of acceptance, 2 months later, you'll have care in the home. So part of what we do in our office is planning for making sure that the care is in place in the interim as well. And we do have ways that we can kind of short circuit some of this, but that is the general process. So how is it changing, you may ask? I have the answers. It is going to change significantly in that the state is consolidating everything into the Department of Health, right? So the Department of Health itself will be conducting these levels of assessments. It's going to be done by what they're calling an independent assessor and reviewed by an independent physician. And there's all sorts of schools of thought and conversations that I am very involved with in this process. I am part of a lobby team through the New York State Bar Association, and we've been in close contact with the Department of Health to share with them our concerns about a lot of these changes. But they're happening. So we're advocating to minimize the effect of it, but there are going to be changes and they are going to be detrimental to the provision of home care services in the community. So having a strong advocate is going to be so important in order to access these services, especially now that with the consolidation of everything into the Department of Health, we expect further delays and bureaucratic loopholes to have to jump through. So in addition to this consolidation process that is occurring and should be effective completely by October 1st, 2020, according to last year's budget, in addition to that, the process substantively how to access care is also changing. So whereas now the demonstration of the need for assistance with any activity of daily living will qualify an individual for services, now you will have to demonstrate that an individual needs assistance with at least 3 activities of daily living, and significantly that assistance must be physical, right? So the statute now actually says that the individual actually needs physical assistance with either maneuvering or hand holding in order to complete the activity of daily living. Contrast that with the current law, which allows for prompting and cueing and supervision, which is much broader forms of assistance for those activities of daily living. So there's 2 things going on in that first bullet point. One is the change in amount, right? It's going from 1 to 3. Now you need to demonstrate the need for 3 for assistance with 3 activities of daily living. And the type of assistance is also changing, whereas now supervision, prompting, and cueing counts for assistance. Under the new regime, only physical assistance will count, unless there's a diagnosis of Alzheimer's or dementia. Which is, that's nice that they acknowledge that. And if those are present, then the number requirement drops down to 2, and you now can allow for the supervision, prompting, and cueing. So that's good for Alzheimer's and dementia patients. However, there's a whole class of diseases and diagnoses that lead to mental incapacity that should also be included in that carve out, right? There's all sorts of other traumatic brain injury or Parkinson's disease. There's all sorts of other diagnoses that could lead an individual to need assistance with prompting, cueing, and supervision with regard to their activities of daily living. So that's some significant changes, and you really want to assure that whomever is assisting you with this is very familiar with these changes and how to advocate and maximize services under that.
And
so what our
firm does as well?
I'm sorry, Elizabeth, I couldn't quite hear you.
And this is something that your firm does as well?
Yes.
Okay.
Yeah, we do a whole lot of it. And
it's difficult and it's confusing, and you want to make sure you're doing and saying and the right thing. Otherwise, it's very easy to be denied.
Yes, absolutely. I mean, our process, just for a little inside information, our process is, we do the planning, we do the application, and then as soon as the application is approved, we set up a conference call or a Zoom call with our clients to go over exactly what should be highlighted, what should not be highlighted in these interviews, and really assure that the family who's assisting with this understands the parameters that we're working in, because you get one crack at the initial apple, and then you're already in appeal land, right? So we always want to make sure that we're creating the most advantageous record that we can, so that if we do have to go to appeals, we have a strong likelihood of success, which we have. We've realized great success in getting people the services that they need. It's just unfortunate, quite frankly, that we're needed in that regard. But nevertheless, it is what it is. And we have, through many years, perfected advocacy under this regime, and will continue to do so. So you may be asking yourself, well, what is an activity of daily living? And it can, they're listed on these two slides. It's pretty much anything that you have to do to be able to independently live alone in the community, right? It's food shopping, cleaning, getting to the doctors, managing your bills, and then it's even more personal: bathing, dressing, grooming, transferring, standing up from a seated position, using the bathroom, using the toilet, incontinence care, all of that, all of those things that are necessary for individuals to age in place really constitutes activities of daily living. So that's what's on the horizon. There are some things that are happening even now in this realm. So I indicated that right now, currently, the managed long-term care plans are doing these assessments to determine how many hours of care are provided. It has recently, currently, it dropped from 2 annual assessments to 1 per year, which is significant for individuals who are dependent upon these services in order to remain at home, because 1 year can really recognize significant decline. So it has dropped again from 2 to 1. And the other kind of interesting thing that's going on here is that there's no new MLTCs allowed into the market right now. There's a moratorium on new applications for MLTCs. And essentially, the Department of Health has a mandate for phasing the MLTCs out of existence. So even while all of these reductions to the MLTCs are happening, and DOH, the Department of Health, is imposing caps on the individuals who can enroll in MLTCs. Nevertheless, it's still mandatory for consumers to enroll in these MLTC programs. So that's all to say that it's becoming increasingly difficult to independently secure and maximize these services, even after you've done the appropriate financial planning. So with that very broad overview, I'm going to open it up to questions, and I'm going to stop screen sharing now as well.
Perfect. Yes, we are. We have a lot of questions. That was very overview to you, but very interesting to me and our attendees, and very important information. But we do have some wonderful questions, so let me jump right over to that. John has a question. He said, there's a lot of information, and for a neophyte individual, can they manage this on their own, or is it really advisable to hire someone? And he's asking, is that something that you do?
Yeah, so you do not need a lawyer. It's not like going into court. Like even court, you can go in on your own, right? So you don't need a lawyer. Is it advisable that you partner with someone who knows what they're doing and knows the system? Absolutely. If you want to secure services in any kind of expedient fashion, you really need an advocate who understands this Byzantine system. Yes, it's certainly something that we do. I devote my practice to this, and we have a whole team here that is ready, willing, and able to help.
I just shared your contact information.
Thank you.
But what would be the next step for someone who said, you know what, I may be in this situation, I need some help? What would be the next step in working with you?
So the way we work is we do a consultation, right? So we send out a questionnaire that has a whole bunch of information that we ask you for. So it's financial information, it's information about what your care goals are, right? So not every family looks the same, right? We really take an individual approach to each of our cases. So we send out this kind of robust questionnaire. We ask you to complete it to the best of your ability and to bring it with you to a consultation that typically lasts about an hour and a half to 2 hours. And we sit down with you and anyone that you would like for us to share the information with. Some people want their families involved, some people don't. And we just go over your specific situation and plan for what your goals are. And we will provide strategies for the financial savings, and then also, as I indicated, strategies for actually securing the care once the financial part of it, which in my view is the easier part, is squared away.
Says the expert. The expert, because it's easy peasy for them.
Well, like I said, there is just more definition to it, right? The accessing the care is much more subjective. It's an individual assessor who's doing the assessments, whereas with the financial eligibility, there's statutes and there's law, and yes, an individual is reviewing it, but there's not like a whole lot of subjective analysis of the finances. They are what they are. The transfers are what they are. Math is math, right? So that's basically what the finances come down to. With the accessing and maximizing the care, it is much more subjective. You really have to be very in tune to what the questions are that are being asked of you, why they're being asked of you, and how to appropriately respond to them. And that is just a skill set that is developed over time and not going to be innate to anyone who's approaching the system as a neophyte, as someone said. I like that word.
Yeah, me too. That makes a lot of sense. Thank you. Wendy wanted to know, when you were using the term homestead, what do you mean by that? Do you just mean the home? Is that just a legal term?
Yeah, it's your primary residence, right? So it's not your vacation home. It's not your RV. I've had someone try to do that. So it's your home. It's your primary residence.
Okay, terrific. That answers that. Thank you. Alyssa said, currently my individual has CDPAP. And the okay, yep. Thank you. And the agency is not managed care. It allows us to keep straight Medicaid. We have self-hired caregivers, not agency caregivers. Will that stop?
So CDPAP, you actually will ultimately have to enroll in an MLTC. You may have received it under an immediate needs structure. So CDPAP is also going to be subjected to the same rules that I just indicated. But if you're already in the system, you should be grandfathered in at least for the financial eligibility stuff. It's still up for debate whether you will be grandfathered in for the new regime for qualifying for the services. That said, for DSS, the Department of Social Services, to actually terminate or reduce services, they have a much higher burden. So I mentioned very quickly, kind of glossed over this, if you think you may need services where a loved one is in need of services, better to get them now, sooner, before all these changes come into effect. Because once you get the services under this regime, it's going to be much more difficult to discontinue them just for procedural due process reasons.
Got it. In fact, that kind of leads to Maura's question. She said, is it important to apply for Medicaid as soon as possible in order to start the clock? So I guess that would be a yes if there's a need.
If there's a need and it's determined that you're going to be successful in your application, of course, right? Yeah.
Right. Okay, perfect. Olga wanted to know, if a caretaker child lives with mom, takes care of her, but works full time, can this child be deemed a caretaker child?
Yes.
Terrific. Short answer, perfect answer.
Don't you love it when attorneys give short, direct answers? Yeah. It's exceedingly rare.
So Lee wants to know, what happens if the house value is over $910,000? Assuming life estate deed in place on deed, what happens if Social Security amount is over $16,000 for a widower?
Okay, hold on. There was a lot of questions. I'll put in.
Lee wanted to, let's just jump on that first one. What happens if a house is valued over 910,000?
So only the equity, it's actually 906. Let's not forget that 4,000.
Okay.
The equity over that would be considered an available resource. And so we have strategies to deal with that. If that is already a life estate deed, as you may have indicated, we'd have to look at it depending upon when the transfer was and the age of the life tenants. There's calculations that would be done in order to determine the effect of that. Social Security, what was the question there? I didn't quite...
What happens if Social Security amount is over 16,000 for a widower?
Well, so what I didn't really touch upon in this webinar is that assets and income are treated differently under Medicaid. So income is sheltered in a completely different way that we didn't even touch. It's called a pooled income trust. So we would utilize that in order to deal with income overages in the community. So it was very difficult for me to par down what I thought was important to share today, but that's certainly an important thing. Maybe we'll do another one of these.
Yeah, absolutely. So yeah, I mean, I think also, with all of these individual situations, everything's going to be slightly different.
Correct. Which is why it's important to speak to someone about your own individual situation, and do not rely upon your neighbor who said, I did this, because it just may not be appropriate for you. And your neighbor may not have a class of exempt resources that they can gift to. So, it's really important to speak to someone who really knows this stuff to get a handle on what your unique situation is.
Absolutely. Dee says, I have a revocable trust, but based on what you said, I should have an irrevocable trust in order to qualify for Medicaid.
So a revocable trust provides a lot of benefits, right? And it's very good for certain situations. Not so good for exempting resources for Medicaid purposes. It has no effect at all, right? So if your goal is to qualify for Medicaid, the revocable trust would not be appropriate. But that's not to say, Dee, that it's not appropriate in your case. And I don't know what assets it's holding, right? So this is something, again, that you should sit down with someone, review it, talk about what your goals are, and see if it's appropriate. And what's appropriate when you're 50 may not be appropriate when you're 65, right? Things change, life changes. So it's good to just, touch base with someone as your life and life events occur.
Terrific. We had a couple of people ask, Marcy and Bill, what is MLTC? What does that stand for?
Managed Long-Term Care Plan. It is just the acronym for those insurance products that that administer the Medicaid benefit.
Terrific, thank you. And Josephine wants to know, the 2-year look back that you're talking about, does that replace the 5-year that had previously been?
So 2.5 years, and no, the 2.5 year is applicable to community-based Medicaid. The 5-year is still applicable to institutional-based Medicaid, which is nursing home Medicaid, right? So today we were focused on the long-term care in the community, which is the 2.5 year look back.
Okay, thank you for that clarification. We had a couple people ask, when you mentioned about the dementia and the Alzheimer's, what about mental health issues and autism?
Right, no.
Nothing.
So the only thing I can say, well, autism in particular would likely be administered through the OPWDD program, which is not this MLTC long-term care in the community paradigm. It's a whole different Medicaid program. So that's one issue. Mental health, unfortunately, is just woefully underrepresented in these models altogether. So you kind of have to squeeze them into another category, which is difficult. We actually, at our firm, we have a whole department that is devoted to mental health issues. So I've had the opportunity to work on a lot of those cases with people who really know the mental health world, but it's difficult through the Medicaid programs.
Wow. Yeah, we have a lot of questions. We had a lot of questions about that because obviously that is a big issue.
Mm-hmm.
Karina wanted to know, what do individuals that currently have the trust and the in-home care, as you described, should be prepared for? Are there changes that they should be aware of?
Yeah, well, so one of the changes that's occurring right now is that your MLTC is not going to reassess every 6 months as they used to. So what does that mean? It means that it's more difficult to get adjustments in hours, right? So if there's been a change in circumstances, you really have to bring that to their attention and demand that they do reassessment. So that's just one change that is occurring right now and has had significant impact on my client base. To come, we will have to see. I mean, there's strong arguments that the new levels of care should not be applicable to individuals already enrolled, but we're just gonna have to see as they're starting to implement it, how it pans out.
Sure.
Unfortunately.
Bruce wanted to know, is it a good idea to do general estate planning, issues upon death now, and then Medicaid planning later if needed?
Again, it's really going to be dependent upon your own particular situation. So, right, like, first of all, there is no one that I can think of that shouldn't do some sort of estate planning, even if it's just having an appropriate power of attorney and healthcare proxy. Everyone should do that, right? Like, if you have anyone that you love or any asset at all, you need those two documents. Note, caveat, the power of attorney law is changing in June too, so stay tuned for that. But so that basic estate planning is certainly something that people in their 20s and 30s should be doing, right? That's going to look very different than what someone in their 50s is going to do, opposed to what someone in their 60s and 70s is going to do, right? So it's really, I've been saying for quite a long time that elder law is really a misnomer. I have a whole program that I do that's called elder law, not just for the elderly. It's a misnomer. Everyone should really be looking into this stuff. And, estate planning is one thing, and then you may want to be looking at long-term care insurance as you're doing that as well. So there's a lot of considerations that are very specific to your own particular needs and wants, really. This is really about managing your healthcare on your terms.
Very good point. And I think that's a really perfect segue to the end. I mean, we could literally spend here all morning. There are so many questions, and I really encourage you to reach out to Moriah. We do have her contact information here. I'm actually going to share it right again now. You will also get an email tomorrow with her contact information, so you can reach out. Please don't put this stuff off. I know that when I, got my will and just the beginning of it, I know I felt like a million weights were lifted off my shoulders. So making sure that you address this, at least ask the questions and know what you need to do to prepare, whether it be tomorrow or whether it be, in a few years from now or 10 years from now. Being prepared is so very important. So thank you, Moriah, for this incredible information. This has been extraordinary and super helpful. There's been a lot of questions about the slides. As I mentioned, this has been recorded, and you will be able to see this again and again and again and be able to share it with your community. So that link will be emailed to you tomorrow. It'll also be up on the Schneps Media YouTube channel. And I know that Moriah will follow up with you with some more information. And again, I just thank you, Moriah.
Thank you.
I want to thank our attendees for spending their morning into afternoon with us. Hope that you gleaned a lot out of this. I know I did, and look forward to seeing you on a future webinar. Please, everyone, stay healthy and stay safe.
Thank you so much. Have a good day.
Have a wonderful day. Bye-bye.